Well, I'm noticing a pattern, a problem at the United States Supreme Court, ladies and gentlemen, that the leftists on the court, Kagan, Jackson, Sotomayor, and more the rhinos on the court, led by the Chief Justice Roberts, Kavanaugh, who's unreliable, and Barrett, who by the end of her term, I believe, will have flipped all the way to the left. They have a new tactic. And that tactic is to let stand what's being appealed to the court by simply claiming there's no standing. Well, standing is a legitimate issue, but in the case involving the attorneys general of two states who challenged what the Biden administration was doing, particularly with Facebook, but also Twitter, that is significant pressure placed on them to determine what would be made available to the American people to manipulate and control information providing to the American people on these social sites. The idea that there wasn't standing is really preposterous. In a federal district court that was so appalled by the factual evidence that it received, and the district court is the trial court level, that judge actually imposed an injunction on the government. Then you had the appellate, that is the circuit court above him, the Fifth Circuit, a panel that lifted the injunction, but also said that this is a significant breach of the First Amendment. It raises many questions. And then you have the Supreme Court that says, I'm sorry, there's no standing here, Mr. Producer. What? If you really want to understand what's at stake, you read Sam Alito's opinion for the dissenters. The dissenters are the hard and fast constitutionalists, Thomas, Gorsuch, and of course Alito, who wrote the opinion. I'm extraordinarily troubled by this. Now notice I'm not going to demand that the Supreme Court be eviscerated as an institution. I'm talking about something else. I'm telling you that Barrett has decided that she's a politician, not a justice. Kavanaugh puts a wet finger in the air and will go one way or the other. Roberts claims he's protecting the institution of the Supreme Court when in fact he's destroying it. And so immediately, the spokesperson for Biden said that they're going to now continue what they were doing, and that is trying to ensure that disinformation doesn't reach you. This is a fascistic/Marxist mindset. The Supreme Court just ducked a critical free speech First Amendment issue with a government, the Biden regime, is trying to manipulate and control information that's provided to you and me. Whether it's involving the vaccines, whether it's involving the Hunter laptop. So now the Biden regime and other like-minded police states are going to be encouraged, motivated to do this and more. And the person who wrote this majority opinion, hiding behind the standing issue, was Amy Coney Barrett. I've been the first to call her out with you. The first to say, you better watch out. What she's doing is problematic now. Then a piece came out about how she disagreed with Clarence Thomas, who did a historical analysis and one of the opinions, and she said, we're not bound by that. And I said, uh-oh, here we go. It underscores the fact that she doesn't think she's bound by anything. So there you have it. There you have it. This isn't Chief Justice William Rehnquist. It's Chief Justice John Roberts. He's a disgrace. He's buddies with Thomas Friedman. He's gone full Washington social circle. This is often typical of justices like Anthony Kennedy, among others. The late Sandra Day O'Connor, even Harry Blackmun, the author of Roe v. Wade. It's a huge problem. Maybe the Supreme Court should be placed in another place. Maybe Palestine, Ohio. I don't know what game the court's playing now. We're waiting for the immunity case, the obstruction case, and what nobody's talking about, even our brothers and sisters on Fox, is the case involving the Chevron decision. The Chevron decision was really the mother of all attacks on capitalism and representative government. And it is the decision. There were other decisions, but it's the pinnacle. It gave so much power to the bureaucracy to write laws and rules and to rule over us as opposed to Congress. And as I told you the other day, unfortunately, Antonin Scalia was involved in that, but later on he regretted it, and he was poised to reverse on that. But, of course, he passed away. So there's a case in front of the court right now that Landmark Legal Foundation is also involved in to fight this former Chevron decision and give us our republic back. All the so-called legal scholars on TV, not one of them has mentioned it. Not one. I also want to remember when the immunity issue was raised by President Trump, there was only one lawyer in the media, only one, who said this is a serious challenge. Remember that, Mr. Producer? Remember this? I mean, it's amazing now. They're all there. This is a serious case. I don't know what the Supreme Court's going to do. Nobody does. 3 of them follow the Constitution. 3 of them are up in the air, and 3 of them hate the Constitution. So there you go. But the fact of the matter is, it was always a serious matter. And it remains a serious matter. Your host is also the first one to call out the so-called documents case. Oh, that's a slam dunk, said Bill Barr and his acolytes in cable legal analyst world. It's a slam dunk, you know, he should have turned it over. He was asking for it. It's not a slam dunk. And again, we were right here and they were wrong. That's why you're here, quite frankly, because I don't go with the crowd. I go with what I know. There's nobody more experienced in filing briefs and dealing with appellate courts and the Supreme Court, I'm being honest with, than I, from my work with Landmark Legal Foundation. I saw one person wrote a piece, long piece, as is the individual's one, basically cherry-picking from the 2 briefs that were filed in the challenge to the appointment of Jack Smith under the Appointments Clause. I don't work that way. I don't cherry-pick other people's briefs. I will read from them and quote from them and give them the credit they deserve. But it was somewhat confounding and incomprehensible because you got to learn when you're a lawyer to say things in a way that the average person who didn't go to law school and didn't get all confused by all that stuff can understand and relate to. If you don't, it doesn't matter. You're just writing to impress yourself and people around you. It doesn't work. It's different when you file a brief with the court. You're dealing with the same kind of background, the same kind of profession. That's fine. It's like when everybody asks, what medicines do you take, Mark? The name of the medicines, Mr. Producer, are so complicated. I don't know. I just take what they tell me to take. Well, is it this one? I don't know. And same thing. If you had me wire a house as an electrician, I'd burn it down. If you asked me to do the job of a plumber, I would know hot from cold. I know what I know, and I know what I don't know. But if I'm using information provided by somebody else, so forth, I would say, plumber XYZ told me, good guy, that's what we do. No, it doesn't work that way, apparently, anymore. This is basic ethics. So the piece was picking from the two briefs, the Mukasey brief and the Landmark brief. And, well, that's not the way you're supposed to do things. But the documents case has many serious aspects to it, as we said here. The appointments clause is a very, very serious matter, as we said here. How did I know? Because Landmark's been working on it. And because my former boss and mentor, Ed Meese, working with two professors, one of whom was a colleague of mine at the Justice Department, Professor Stephen Calabrese, he told me, we knew, I read it. Serious matter. So the appointment clause is a serious matter. The documents case has serious constitutional issues. Everybody's now sitting and waiting for the immunity case where they all dismissed it. Every damn one of them, didn't they, Mr. Producer? Way over the top. I mean, way over the top. Now, I don't know how the Supreme Court's going to rule America. I don't know if they're going to cut the baby in half or hand the baby over to Biden or whatever. I'm sure Trump won't get a full victory if he gets a partial victory. But I don't even look at things that way. I look at it, what does the Constitution say? And if it says nothing, did the framers provide us with any guidance whatsoever? And if they didn't, then you know what the third test is for me? Then how do you do the least amount of harm to these institutions? How do you do the least amount of harm to these institutions? Barrett has become a disaster. However she votes, doesn't matter. She has no working doctrine on how you interpret a court. She's clearly not an originalist. And if you stray from being an originalist, you're nothing. You're making up your own rules as you go along, but you have nothing principled based on the Constitution, based on the framers, based on the history to apply to your decision, other than you happen to be somebody who's on the court and you feel this way or that way. So this was an abomination today that the court did not have the courage to take on what is a black and white case of an administration undermining the First Amendment, trying to control freedom of speech, and now it's going to go further. Supreme Courts in the past have made horrendous decisions. The fact that this court made a decision to hide behind standing where the lower court and the circuit court didn't find any standing problems will be one of the reasons why it will be condemned. There'll be reasons why it will be praised. But this will be one of the reasons it'll be condemned, because without free speech, we have a tyranny. And this is a black and white case where every aspect of the bureaucracy was used to try and shut down even discussion online among American citizens, sharing information, right or wrong, good or bad. And yet the irony is, it was the federal government. The 6-foot rule was based on nothing. The vaccines were not adequately tested. And all the rest. They just handed the Biden administration a massive iron fist. Good job.